Hey guys, this is Scott Horne. We're going to take a minute and just talk about some of the probate processes that will help you navigate your real estate transaction. This is not intended to talk about the probate industry itself, but just how we navigate some things for real estate purposes. So if you find this video helpful, don't forget to take a moment and like the video. Don't forget to comment below. We'll do our very best to answer those questions for you. And don't forget to take a moment and subscribe to our YouTube channel as well. So let's just jump right into probate for a minute. So probate, of course, arises when someone passed away. And whenever you run into a probate, it is so important to know what kind of questions you need to be asking. And probably the most common is, and unfortunately for us guys, the women kill us off first, and they always seem to survive. So oftentimes you're dealing with maybe a mother, a wife, someone who has passed away, and you're talking with their heirs, their children, whoever it might be. One of the first things I always ask is, especially when it's involving the real estate, is was there a husband involved who owned the property also? And a lot of times the answer is yes. So of course my follow-up question then becomes, was his estate probated? Now, if there had been a divorce and the wife got the property in the divorce, you need to know that. You need copies of those documents to verify and validate. Was there a deed from husband to wife? You've got to go through this litany of thought process to know where you stand. Was the father's estate probated? Was an heirship affidavit done for them along the way that conveyed the property to the wife? But then you've got to ask, was this marriage only one time between husband and wife, or did they have other marriages and or other children? And this is where things get messy really quick. What you find so often in the probate world is a husband passes away, the wife thinks because she's married, everything is hers, and come to find out when she dies, the husband had 2 children by a prior marriage. Let's say, for example, maybe this particular husband and wife had 2 children. So the 2 children who think that they own the entire house maybe only own 50% of the home. Getting a grasp also of the basic laws of intestate succession in the state where you live is so important. What that means is if you don't have a will, because a will define who takes assets under the person who passed away. And so often there is no will. So when there is no will, then it's whatever the estate's code is going to stipulate, or the probate code will stipulate in the state where you're located, as to who gets what. You don't need to be an expert at it, but you kind of need to know just some basics on down the line. And of course you can get a good grasp by talking to knowledgeable title people, maybe a knowledgeable attorney, and just getting the feel for the first couple of levels of that will help you through most of the deals that you deal with. Now, when you're dealing with a probate scenario, obviously I try to find the path of least resistance along the way. For the conveyance of real estate, that is an heirship affidavit. It is the cheapest, it is the quickest. It doesn't mean not to probate the property, but it simply is a good way to navigate those items. Now, as a lawyer though, when I'm talking to this person about an heirship affidavit, I'm also going to ask what other assets are out there. If it's only the house and that's it, things are pretty easy. If there's a ton of other assets, you may have to elect to go a different way because an heirship affidavit may not be sufficient, not just for the real estate, but for the other items. And what you don't want to do is charge this seller or this estate more money when you don't have to do that. So there's a time and place to know when to incorporate that probate lawyer and maybe when not to, and use the real estate lawyer to prepare those heirship affidavits along the way. Sometimes, and I'm going to say this is probably 10 to 15% of the time, there is a will. And here in Texas, you can probate that will up to 4 years after the death of the decedent. If you do not probate the will in that time frame, you're barred from doing so. There may be some exclusions here and there, but you would need to talk with a proper probate lawyer about what those may or may not be. In addition, if there is a will, the question becomes, who is taking under that will? Is it just one person? Is it all the heirs? How is it set up and structured? Who are you dealing with? I've seen situations where maybe you're dealing with one heir and they find out that under the will, several heirs get the property, not just one of them. Or maybe it's vice versa, where one heir thought they were getting everything under the will, but it really winds up everybody's getting it. And so it helps you to navigate what the best course of action is, heirship versus some type of probate. Now, there are some different levels of probate out there that can help you facilitate this. There is what's called a small estates affidavit when there's not a lot to be navigating. You don't need a full probate to handle situations. A small estates affidavit, which is a shortcut in the probate marketplace, may help you navigate the conveyance of that real estate. There's also another short probate called filing a will as a muniment of title. And that basically means muniment is evidence of title to whoever is listed in the will. Every situation is a little bit different. Of course, the quickest mechanism is the heirship affidavit, but that is going to follow the laws of intestate succession. If the will leaves property to different people, maybe those people in the will aren't willing to share with the other heirs. Maybe they are. And they can make a joint decision together in how to navigate those scenarios. Now, I see in the probate world a lot of confusion. A lot of heirs believe because there is a will, and maybe it is a valid will, and they're named as an executor in that will. That means that they can automatically start signing documents as an executor. Not the case. A will is nothing more than a piece of paper until it has been filed with a court and an executor has been sworn in. Then that executor is issued what is called letters testamentary, which empowers the executor to act on behalf of the estate. And so to navigate our real estate world, understanding a little bit about an heirship affidavit, when to use it, a muniment of title, when to use it, maybe a small estates affidavit, maybe a full-blown probate. One of the keys is getting that executor appointed in a full-blown probate who can then sell that real estate on behalf of the estate without any further issues or options. And everything's a little bit different, and of course each one of these costs different dollar amounts. And so besides getting a grasp on some basic probate strategies, it's important to know the cost of these strategies, the time basis of the strategies, and it's important to ask the right questions. As I said earlier, was there a dad? Is there a mom? Was dad's estate probated or not? Because oftentimes we have to go backwards and probate his estate to bring things current. And it's just taking the time when you're meeting them and asking as many questions as possible, taking good notes, so when you leave that meeting with those heirs, you're able to convey good information to either your probate lawyer, your real estate lawyer along the way, where they can then help navigate the proper mechanism for what it is you're dealing with. So guys, I hope you found this helpful. This is not supposed to be an in-depth look at probate, but just simply a short synopsis of how to manage real estate for us investors when our probate may be involved. If you liked it, take a minute and like the video. Don't forget to comment below, and don't forget to take a moment and join our YouTube channel. We look forward to seeing you all next time.